I'm Shirley Wyles from BLM Edinburgh. I'm here today with Andrew Gilmour, a partner in our Glasgow office, and we're going to talk today about the current reforms to the Scottish courts. Andrew, can you tell me something about these reforms?
Well, these reforms are imminent. They're about to take place at the end of September 2015. The question is, what does it mean for insurers? My view is it's a curate's egg. There's going to be good news and bad news for insurers.
Okay, well, let's start with the good news.
Well, the good news is that no new personal injury actions under £100,000 can be raised in the Court of Session. That means that the expenses may be lower because there's no automatic right of counsel in the Sheriff Court. And thirdly, the motor claims that we have under £5,000 will have to be in the Sheriff Court in the simple procedure, which will save money and expenses.
Okay. Can you tell us about the bad news?
Well, the bad news is that jury trials are going to be available in the Sheriff Court in the All Scotland Personal Injury Sheriff Court in Edinburgh.
And jury awards can be high. There's been a very high one recently, hasn't there?
Yes, there's a recent case of Brig Bray in June 2015 in which a civil jury in the Court of Session awarded £140,000 to the partner of a 35-year-old deceased.
You mentioned the All Scotland Personal Injury Sheriff Court. Tell me some more about that.
Yes, this is an innovation. An All Scotland Personal Injury Sheriff Court has been created in Edinburgh, which will hear cases from all over Scotland and will have specialist sheriffs hearing the cases. Also, civil jury trials will be available in that court for actions above £5,000 and under £100,000 in relation to personal injuries. It will still be available in the Court of Session over £100,000 for personal injuries, but it won't be available in the local sheriff courts.
So what's going to happen for claims involving accidents at work?
Well, Shirley, for claims involving accidents at work, from £1,000 to £100,000, they can be raised in either the All Scotland Sheriff Personal Injury Court
in
Edinburgh, or in the local Sheriff Court. They can't be raised in the Court of Session. Also, for claims involving accidents at work over £100,000, they can still be raised in the Court of Session.
And are motor claims different?
Yes, motor claims will be dealt with by simple procedure in the Sheriff Court up to £5,000. Beyond that, between £5,000 and £100,000, they can be raised in the local Sheriff Court or in the All Scotland Personal Injury Court. Above £100,000, motor claims can be raised in the Court of Session. Okay,
so summarise for me the difference between motor claims and EL claims.
In the new system, accidents at work claims will be dealt with in simple procedure up to £1,000, whereas in motor claims it will be £0 to £5,000 in this simple procedure.
So what's the outcome of all this going to be?
My view is that there's going to be far more volume motor cases heard in simple procedure compared to EL claims. EL claims will be seen less, and there will be hopefully a saving in expenses due to this.
So with all these new procedures and the financial limits, who decides if a case is worth less than £5,000 or if it can be raised in the Court of Session and it's worth more than £100,000?
At the outset, the pursuer decides the value of the case and which court the case is to be raised in. However, as these cases go on, it's quite likely defenders will be taking issue with certain cases that have been raised in the wrong court, with the wrong value assessed or the wrong type of case in that particular court.
So lots of change in the offing, but is that the end of it?
No, unfortunately not. We still have the review of costs, expenses in Scotland to be finalised. We have the Taylor Review, and that's yet to be implemented in legislation. That's going to take place next year. Also, we have the workings of the Civil Justice Council in Scotland. They have a rolling programme of reform, so their reforms are continuing. Beyond that, they're currently looking at having the voluntary pre-action protocol become compulsory.
So watch this space.
Indeed.
So crucially, Andrew, what do insurers and other BLM customers need to do to prepare for these imminent changes?
My advice firstly is don't panic. There are certainly positive aspects of these reforms that will be beneficial to insurers and our customers.
There may be reduced costs.
Exactly, reduced costs, and also the cases may be heard in a more efficient way. In relation to the negative aspects, our customers need to consider what courts these claims are being raised in going forward, and also whether they're going to civil jury trial. They need to keep a close eye on these issues and employ arguments at times in relation to choice of court and also sanction for counsel.
And that's something that BLM will be keeping a close eye on as the changes are introduced.
Yes, BLM covers the whole of Scotland, and we're well experienced in using all the courts at all levels in Scotland too. We'll be there to navigate our customers through these changes.
Thank you, Andrew.